So, in this video, we'll discuss the question number 2 relating to patent laws. What do you mean by infringement of patent? Discuss the remedies available to the plaintiff in a suit for infringement. So, we will first discuss regarding patent infringement, and in this connection, as the patent holder has exclusive rights to use or sell or license his patent rights, he can keep away others from using, copying his patents. Patent holder can sue the infringer for damages and for compensation. The classic example of patent infringement is the bone of contention between two Indian motorbike manufacturers, the Bajaj and TVS, for the technology used in 125cc motorbike. Bajaj accused TBS of copying its DTSJ digital twin spark plug ignition technology. However, TBS claimed that it had developed its own CCVTI controlled combustion variable timing intelligent technology. Bajaj had contended that it holds the patents for the twin spark technology for small engines, while TVS had said its motorbike model Flame was fitted with a three-valve engine working on the CCVTI technology, which is different from Bajaj DTSI. In 2007, when Bajaj launched its XD 125, TVS launched its Flame 125. However, with the patent war to the Supreme Court, Bajaj sought a restraint on manufacturing and selling of two-wheeler TVS Flame. So, this very contention between these two Indian motorbike companies was in 2007. So, exactly, patent infringement are of three different kinds. One is direct infringement, and the second one is induced infringement, and the third one is contributory infringement. And when there is overcome patent infringement, then it exactly means that it is to prove that you are compliant by data that shows you are not infringing, or you can argue that the asserted patent is invalid, and once it is becomes established of infringement of patent, then you can stop selling or making the infringed product. So also you can negotiate licensing fees from the patent owner. So also to sell, import, use, making the product, that someone else hold the patent without his permission would be considered as patent infringement. And as you discussed, it could be direct infringement or indirect or induced infringement, contributory infringement, and later on we discuss regarding overcome patent infringement and in what circumstances such infringement would be considered as overcome patent infringement, and those regarding remedies as we found. One is injunction, the second one is damages and seizure and destruction of the infringing goods. So, these are the civil remedies available to the original patent holder. So, the very injunctive relief is temporary and it stops the alleged infringement until the dispute can be had at court. And as damages could be awarded in the form of reasonable royalties to the real patent holder, and also in regards to loss of profit or the profit lost as regarding infringement of the patent right. And these two kinds of damages are available to the real owner of the patent holder. So now we'll go to the punishment section. And regarding punishment, as we found under section 120 of the Patent Act, it could be a fine imposed for infringement on a patent, and that fine would be up to rupees 1 lakh. And as per section 35, if one fails to comply with any direction under this section, in contravention of section 39, which says the very provisions of infringement of a patent, there would be an imprisonment for a term which may extend to 2 years, or with fine, or with both. So, these are the different punishments available under the Patent Act of 1970, which subsequently amended up to 2005. And as already we have discussed, under the recent amendment in 2023 in the Jan Bishwas Provisions Amendment Act, the very aim of that amendment is to decriminalize and rationalize the offenses and provisions of the Patent Act of 1917. And as regarding filing a suit for remedies by the plaintiff, the limitation is of 3 years from the date of infringement as per the Indian Limitation Act 1963. So, in regards to this question, what do you mean by infringement of patent? Discuss the remedies available to the plaintiff in a suit for infringement. So, first we discuss the very meaning of infringement and how, in a case relating to Bajaj versus TVS in 2007, the very question of infringement was raised by Bajaj against the TVS Motor Bike Company, and how there are different kinds of infringement: direct, indirect, contributory infringement, and also what exactly means by overcome patent infringement. So also the different kinds of civil remedies as injunctions, damages, seizure of infringing goods, and their destruction are the remedies available to the plaintiff, and what exactly injunctive relief and what kinds of damages are available to the plaintiff in the form of reasonable royalties and the profits lost by the real patent holder, and all different kinds of punishment as provided under section 120, and how the two relating section 35 and section 39, and the very limitation of filing a suit for infringement by the plaintiff, all we have discussed in connection to this question, and this should be the appropriate and relevant answer to this question relating to infringement of patent and those remedies available to the plaintiff. And in our upcoming video, we'll discuss question number 3, and that is what are the different types of patents in general. Discuss the criteria for granting patents.